Hey, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about, do I need to worry about the New Jersey inheritance tax? So I'm going to share my screen with some thoughts. Um, First, what is the New Jersey inheritance tax? This is a tax at death on who inherits property. Um, And this is different than the estate tax, which is how much. So the New Jersey estate tax on wealth, it's really more on wealth, was repealed in 2018. So when you say, oh, but there is no more New Jersey estate tax, you're correct. But they retained the New Jersey inheritance tax, which is very dependent on who is inheriting from you. So let's look at that. So when you leave your estate to spouse, children, grandchildren, there is no problem, right? They are Class A beneficiaries. Class A beneficiaries, no New Jersey inheritance tax. Okay, that's most people. Also, if you leave your estate to charity, it's no problem. Okay, charities are exempt. So, when is this something to worry about? Okay, if you leave some or all of your estate to the following, we have to talk: siblings, nieces, nephews, friends, and life partners. Why? They are regarded as Class C and D beneficiaries and they trigger a tax. Okay, so Class C and D beneficiaries trigger a tax, typically 15 to 16% of the asset value at your passing. So if you are leaving an estate of, say, $1 million to your nieces and nephews, that's roughly $150,000 of New Jersey inheritance tax. It's more nuanced. There's some graduated rates and it depends on Class C or D, but broad brush, there's an issue. And if you have a larger estate of 3 million, for example, of course, multiply that by three. Now we're talking 450,000, and this is a significant sum. So that tax is due 8 months after date of death, and it is paid by your executor or trustee. And it may be paid either off the top of your estate or by apportionment, which is to say a share back from everyone who inherited in accordance with their status, but that is a mess. Okay. So, this is a real thorny problem that exists if you plan on staying in New Jersey for your retirement, and you may pass as a domiciliary of New Jersey. So, how to deal with this? If you find yourself in this category, you're a solo senior, or you have a life partner, not a spouse, you have no children, you have some options. Don't die in New Jersey. Move somewhere else. If you ever need assisted living or anything, consider hopping the fence to New York, or some other state if this is a significant number for you, or leave assets to charity, some or all, right? Um, or if your status changes, stepchildren are exempt, for example. So if you remarry and you have stepchildren, remarry with stepchildren, your new spouse and stepchildren would be exempt. So there's a few possibilities here, but as of now, if you see yourself in any of these scenarios, other than leaving money down the bloodline to spouse, children, and grandchildren, you should definitely have an estate planning consultation to understand where the exposures are and what the solutions might be. Um, Most people don't have to worry about it, but I'd say 15% of our clients do fall into this category. So, if so, plan ahead. There are some things you can do to mitigate. Okay. Hope this has been helpful. If you'd like to learn more, simply go to our website at irinashea.com, click the Get Started tab, and our initial consultations are free of charge. Thanks.